My name is Michael Fallings. I am the managing partner here in Austin, Texas. You can see the bio on my screen. I've been practicing labor and employment law for over 10 years now. I've been practicing in Texas for now over 5 years, and I've been doing federal court work for over 10 years or close to 10 years. And I'm highly experienced in mediations in the federal court level and including in Texas. I'll turn it over to my colleague Sean, who he wants to introduce himself.
Good afternoon, everyone. My name is Sean Timmons. I'm the managing partner of our Houston office. I work with Mike on cases around the state of Texas and across the country and around the world. And I've been an attorney for 16 years now. I've been in private practice for 14 years, and I've been 8.5 years with Tully Rinckey. And I've mediated cases up and down the state of Texas and across the country. And I'm involved in several litigated federal court matters in multiple states and around the country right now. In fact, I just returned from Alabama this morning, and I'm docketed for trials next year, basically 1 or 2 a month across the country. So we've got quite a bit of experience between the two of us, and happy to share our knowledge with everyone today.
Okay, thank you. So as you know, today we're going to be talking about federal court mediations in Texas. We'll be talking about the strategies to win a mediation in Texas, how to prepare for a federal court mediation in Texas, the requirements and steps to engage in the mediation, how does mediation work, and all the rules that govern. Everything we're providing here today is for general knowledge. It's not meant to replace any specific legal advice for your specific cases. And as we'll repeat at the end, if you do require an attorney on your specific case, then you should consult an attorney. But our goal today is to provide general legal advice over the federal court process, mediation process in Texas. Okay, so with that said, the first thing we just want to go over is, what is a mediation? Well, a mediation, the purpose of mediation is to try to resolve a legal dispute. A mediation involves two parties. It involves a neutral official called a mediator that is helping to try to guide the parties to try to resolve the case. In federal courts, the mediators often or can be a federal judge if the parties choose. It could also be a private party that's a former judge or an attorney in the area. But again, the goal of mediation is to discuss settlement resolution of the case. Now, mediation is an avenue to discuss resolution, but anything that's discussed is not evidence that can be presented in your case. It's actually confidential, and everything that's supposed to be talked about during mediation is supposed to be not disclosed to anybody, and especially not in your case. So that provides the parties open and free discussion to try to come to a resolution on the case. Now, you're not required to settle the dispute during mediation. And, just to be clear, when we say settle, that means your dispute is resolved. The dispute will not continue. But the mediator can't force the parties to settle. You're not required to settle. The goal is to try to reach settlement, but you're not required to settle. And if you aren't able to settle, your legal matter will continue. Mediators are subject to certain regulations and standards, as we say on our slide here, regarding guidelines they must face. Mediations, as far as payment for mediations in federal court, that could be up to the parties. If the parties choose a private mediation, then that will be paid for. There are mediators around Texas that mediate different cases. Sean and I have mediated cases across Texas in the past, but if you choose a private mediator, they will require payment. You could opt for a mediator through the court system, where that's an actual judge on a case, perhaps a magistrate judge, that won't necessarily require payment. But that is the party's choice in how they want to go about trying to come to an agreement. But overall, again, I can't emphasize enough, the purpose of mediation is to have an open and free discussion to discuss resolution of the matter. It is confidential. Settlement negotiations are not evidence of anything, but the goal is to try to come to a written agreement, and you're not required to settle though. So that talks about what is a mediation. Now we have more information on the next slide regarding what a mediation is. In mediation, I think it's important to note, if you don't settle during your mediation, you could still have another mediation if the parties choose. A mediation could take all day as well, and maybe you don't come to a settlement. You could continue that over to the next day or whenever the parties choose. You may be at a stage of your case where you've just filed a complaint and you engage in mediation and you can't settle. That doesn't mean you can't go to mediation right before trial. So mediations can occur at any time of the case, before you file, after you file, right before trial, and often the courts in Texas will require the parties to discuss settlement and to discuss mediation through the alternative dispute resolution process. In federal courts, the typical orders by federal judges in Texas will include a deadline for the parties to mediate, and that is equal in state court as well. So that is often the case, that parties are engaging in mediation, and the reason for that is because nothing's guaranteed, and employment disputes, especially that we handle, those matters can often take a length of time, be costly for each party. And again, there's no guarantee of any, result there. So that's why parties want to avoid the risk and go to mediation and avoid the additional costs and avoid the time. And that's why employment disputes are often well suited for mediation. Especially when an employee is still employed by a company or a government agency, because there's ongoing issues. And so to resolve that, it makes sense to try to resolve it now than wait the years it takes potentially to get to a trial. So as I said, and moving to the next slide, the mediations are confidential. In fact, both parties are usually required to sign documents before the mediation, understanding that and agreeing to maintain confidentiality. The parties are required to agree to mediate and agree to maintain confidentiality of the process, before you engage in mediation. And just to make abundantly clear, confidentiality means that anything that's discussed during the mediation cannot be discussed elsewhere. Even if you're taking notes during the mediation, mediators will often require you to destroy those notes, and destroy, whatever you jotted down, if it pertains to the mediation that you were taking notes about, because again, they want to promote that open and free discussion. And if that confidentiality didn't exist, then parties may not want to go to mediation, because parties may try to use what's being discussed in their court cases to their advantage. So again, the goal is to keep everything inside the mediation and to try to get to a settlement. We have another slide here, confidentiality in Texas. This just, specifically means that, the mediators are bound by Texas provisions that they're not allowed to disclose certain information. And another thing in confidentiality is that during the mediations and how they are also run is the mediations will usually start out with a joint session where everybody's in the same room, or if you're doing it virtually, via a virtual room on Zoom or Microsoft Teams or whatnot, or WebEx, and everyone joins and introduces themselves, perhaps gives an opening statement, and states, what their case is about and what they plan to prove and what they want to settle for. And both sides present that at the mediator request. And then the parties go to breakout rooms. If you're physically present, you go to your own individual room by yourself or with your attorney, and the other side does the same. And the mediator goes back and forth between each rooms to talk about the case. Now, when the mediator's in that room with one party, the mediator will usually ask, is there anything you don't want me to reveal to the other party that you just told me? And you could say to the mediator, no, I don't want you to say anything except my settlement offer. Or sometimes you'll say, no, yeah, you could say everything I just said to the other side. And that's that part of the confidentiality again, is that mediators will make sure to not reveal, even during the mediation, any confidences that you've disclosed to the mediator. For example, if you're requesting damages for, any medical issues, you don't really want your employer to know about a certain medical issue, but you've just told that to the mediator, you may say, well, mediator, I don't want you to say this to them, but this is the basis of my demand. Or if you're telling the mediator, well, yeah, right now I'm making a demand of XYZ number, but really I'm willing to settle at, this lower number. You may tell the mediator that for that person's knowledge, but you may want to say to the mediator, well, I don't want you to tell them my bottom line at this point. And mediators will understand that. But those are just, additional examples of confidentiality that's even existing during mediations. And mediators are bound by that per Texas regulations. Okay, I think now I'll turn it over to Sean to talk about further mediations in Texas. Sean, if you're able to go ahead, go ahead.
Sorry about that. I was still on mute. Let me, okay, hopefully everyone can hear me clearly now. Sorry about that, but thank you for participating today. So Mike went through, confidentiality and the overview of the process. And, there's a federal rule on confidentiality and stuff, and we've cited it in our presentation here. But talk about, federal court mediations in Texas. A lot of courts around the country mandate ADR. ADR is alternate dispute resolution, meaning they either want the case to go to either a binding arbitration or to a mediation discussion prior to formal litigation. Why is that important? Because mediation can help reduce litigation costs significantly. You may want to request mediation in writing or orally upfront and use it to avoid significant costs associated with pursuing your claims. Generally people are frustrated by legal expenses, and it's understandable because legal expenses in the federal court system the federal courts are often dealing with cases between Fortune 100 companies. So when Apple sues Samsung and Samsung countersues Apple, or, you name the major corporation, FedEx sues UPS, UPS sues FedEx, they often have 5-10 lawyers each. They're often paying these lawyers thousands of dollars per hour each. And they're often filing massive documents, thousands and thousands of pages back and forth at each other. The federal courts are designed with multiple law clerks per judge to actually read through all that material. So if you're an ordinary person going up against XYZ Fortune 100 company with an army of lawyers, one of their tactics is to bury you alive in paper, to dump thousands of documents on you, to make you basically dig through a haystack looking for that needle to try to find the proof of the corruption you're suing about, or whatever your claim might happen to involve. Mediation is designed to basically cut through the red tape and get to the facts of the case without being buried alive in its contentious, scorched earth type discovery battle, where you're basically in court arguing about the sufficiency of responses to requests for production, or answers to interrogatories, or elaboration on requests for admissions, or content of depositions, timing of depositions, location of depositions. I just spent an entire day yesterday in Alabama in federal court on a pretrial discovery battle hearing between 3 defendants and our client. It took all day. You want to avoid those kinds of hearings if at all possible, because ultimately at the end of the day, did anything get finally resolved? No. The case got jump started and moved, and the judge ordered the parties to mediation. So if you can voluntarily agree to mediation without having to spend an entire day in court bickering back and forth over the content of discovery materials, that would be in your best interest to the extent most possible. Judges often don't want to deal with an entire day evidentiary hearing on the sufficiency of discovery responses. They want you to go to mediation and flush out the issues and see if a resolution can be resolved. What I'll tell you about mediation is, if it's done correctly, neither side should end fully happy. Why? Because it's compromise. You're basically agreeing to voluntarily reduce the maximum recovery you may obtain in exchange for getting guaranteed result. So for a defendant, mediation is great because it reduces their risk, their exposure. A jury could get carried away, could order the plaintiff to receive millions of dollars, and a court could be deferential and uphold the jury's verdict. So you may not have insurance to cover that liability, and the company could go insolvent if it can't pay it. In the alternative, if you're a plaintiff and you're seeking, a recovery, getting a maximum recovery through a jury may not be worth the litigation costs in time, effort, and risk associated with the possibility of losing everything and getting nothing. Mediation generally results in a stipulated settlement with a certain guaranteed fixed amount, and the valuation of it's going to be reduced from the maximum you could possibly obtain from an ultimate litigated recovery. Meaning, if you're a defendant, ultimately you can get completely exonerated and have no liability, but you're going to spend a significant amount of time and effort and attorney fees to get that. And if you're a plaintiff, you're going to spend a significant amount of time and effort and attorney fees and to obtain your recovery. But at the same time, you may not get the maximum value from a jury. The jury may not agree with your side of the story and may award nothing. At a mediation, both parties agree to compromise, and through the compromise process, come to an agreement that is reasonable under the facts and circumstances. And the mediator, him or herself, usually has decades of experience in litigation, has either previously served as a judge or as a litigator, and will know generally what the going rate for your case happens to be across that jurisdiction. Jurisdiction by jurisdiction, valuation of cases can change substantially. Certain locations are known as very jury friendly. Other locations are known more as employer friendly. Unfortunately, me and Mike practice in Texas, which falls under the Fifth Circuit, which covers the states of Louisiana and Texas and Mississippi. And the Fifth Circuit is arguably the most conservative federal jurisdiction with a very pro-employer bias. Since it has a pro-employer bias, values of cases for employment disputes are generally lower in Texas than they would be in New York or California, with more favorable state law to allow larger recovery and more favorable juries that award higher verdicts when responsibility is established. That's one great reason why so many employers have moved their operations to Texas, is because they know their exposure for getting caught breaking the law is actually substantially lower in Texas than it would be in a jury in California or New York or other jurisdictions around the country. So keep that in mind if your family or loved ones considering relocating to Texas. You may want to double check your employment agreement and understand that if you ever have to go after your former employer, Texas is going to be a more hostile jurisdiction than other locations. Not to discourage anybody from pursuing their rights, but we have to live within the reality of the venue where you're litigating. In addition, mediation can help you determine, are you going to get a favorable jury pool, or is your jury pool going to be skewed possibly to be more hostile to your claims? Every claim is different. So factually speaking, you may have a very favorable jury, or you may have a very sympathetic jury pool, or you may have a jury pool that's openly hostile and not really entertaining your claims. That all goes into a valuation assessment on what the overall recovery should be from participating in mediation and making a determination as whether you should settle in mediation. So we can move on to next slide. All right, types of mediations. So there's EEOC mediation. There's voluntary mediation after litigation has been filed. What is EEOC mediation? Basically, the EEOC is the Equal Employment Opportunity Commission. Anybody can file a complaint with the EEOC.gov if they fit the criteria and believe they were treated unfairly based on a violation of statute Title VII, meaning if you believe you were wrongfully terminated or treated unfairly at work because of age, race, gender, sexual identity, orientation, a disability. There's other statuses, pregnancy. If any of those criteria are met, you can file a claim with the EEOC. Now, generally in Texas, it's a right to work state. So if they require you to wear the McDonald's uniform and you don't want to wear the McDonald's outfit, and you say to them, look, I'm not wearing a silly McDonald's shirt, the heck with that. And they say, well, everybody's required to wear the McDonald's outfit at our place of employment. If you don't want to wear it, you're fired. That would be a lawful reason to be fired. Now, if they said only the females have to wear the McDonald's outfit, but the guys can wear whatever they want, that would be gender bias, gender discrimination, and that would be an example of how individuals could say there's a bias in the workplace, a hostile work environment, and unlawful employment action. That's a very simplistic explanation, an example, but trying to make a point here is you have to have a basis to file a claim that violates the statute. So you have to show that, they fired everybody who was over 50. I'm over 50, I'm over, I meet the age discrimination criteria. Or they're only treating women in this way, and I'm a woman, and therefore I feel aggrieved and victimized, and I should get remedy because they're giving preferential treatment to male employees. Same thing if you're African American or Hispanic or any other status, race, gender, religion. Even if you're treating, if you're Muslim and they're treating you harshly or they're mocking you for your faith, that would be an example of religious discrimination. I've actually had a few of those cases where, people were called, derogatory names at work because of their religious identity, and that would be a violation of federal statute, and that would be a justified EEOC claim. So it gets tricky when it comes to evaluation on EEOC claims, especially in the Fifth Circuit. What's sexually inappropriate, what's sexual harassment, and what the law says it is, often are divergent, meaning the Fifth Circuit, it requires a pretty egregious set of facts to establish actionable sexual harassment. What I believe is inappropriate, unethical, and improper may not rise to the level of being technically illegal in the Fifth Circuit. Other circuits may disagree. Other circuits may say, oh, that kind of conduct is absolutely actionable sexual harassment. In the Fifth Circuit, being as conservative as it is, the standard to rise to the level of actionable sexual harassment in the workplace is exceedingly difficult and high. So the point I'm making is, in the EEOC process, you mediate, you flesh out the facts, you make an assessment, and you try to come to a resolution. And the EEOC mediator is designed to see if the former employer or the defendant is willing to come to the table in good faith to try to negotiate a resolution. There is no requirement that your former employer or current employer mediate in good faith, meaning they're not required to participate at all. The EEOC, though, to streamline the process and avoid litigation, prior to issuing a notice of right to sue, will often offer the parties an opportunity to try to resolve their disputes in a informal via Zoom or Teams mediation. I participated in lots of these, and sometimes the employers come in good faith and they offer a decent amount of money. Other times they come and they really don't take it seriously and they offer you maybe $1,000 or $3,000 or something really low to try to make it go away. If you feel you're getting lowballed and they're not offering you a resolution in good faith, you're not compelled to submit to that maltreatment in the mediation process. You can just say, you know what, they're not negotiating in good faith. I'm not going to participate any further, and I want to get my right to sue letter and pursue litigation. So the EEOC mediation process is really hit or miss. We've had success with it. We've also had a lot of strikeouts with it because some EEOC mediators are simply not aggressive. Some employers don't take it seriously. Some take it very seriously, but unfortunately, a good number of them don't take it seriously at all. And on the reverse, I've been involved defending small businesses against claims. And as an attorney, I take the case as individuals hire me. I'm the advocate for those who employ my services. So if a small business hires us and needs to defend themselves from a claim, we occasionally will take those matters on and participate in mediation. And if I feel my client's exposed, I'll advise to mediate in good faith to try to resolve it and make the individual whole to reduce risk and resolve the claim and move everybody's along. Sometimes there is mandatory mediation in contractual agreements. If you sign a contract with your employer and they mandate a certain kind of dispute resolution, either arbitration or mediation, that may be subject to enforcement through contract law. But generally, mediation is voluntary and the EEOC encourages it, but can't compel it to actually occur. Mike, do you want to add anything about any war stories with EEOC mediation? That I rambled on a little bit there, but we've been through a lot of them over the years. Any pointers you want to discuss?
Yeah, no, I mean, I think you covered a lot there. I think,
I can't hear you, Mike.
Can you hear me? Yes, I think I took myself off mute, but all I was going to say was, I think you covered a lot there. Hopefully I'm still being heard. And, the point of mediation, as we discussed, is to, try to resolve your complaint there are certain risks to moving forward, if you don't go to mediation, and it's a free and open discussion, like I was saying, as far as just, stories. I think you have to be flexible. I think we've been in mediations where we'll start at $1 million and then it starts at zero, it may take all day. But if you are, flexible, even if the employer or the other side's moving just pennies, I mean, until you get that best and final offer, I think you should keep on negotiating, because sometimes the employers sometimes strategies is just to, make you tired. Do you start at 9 a.m. and then they're hoping by, after lunch, you're like, okay, just give me whatever money. So you kind of have to hang in there, because, sometimes employers are just trying to offer low amounts at first and see how much you could last, until if you could last to the end of the day, then they may say, okay, we'll give you what you want. So I think, when you're in a mediation, just, just trying to, be patient when you get the lower offers, and just to continue with your strategy and hang in there. And, if you have a representative, to listen to your representative. Go ahead, Sean.
Thank you, Mike. I appreciate that, and absolutely agree. I mean, you got to listen to the mediator. The mediator has a lot more knowledge even than the attorneys. The mediator usually is a seasoned attorney with decades of experience, and generally they're in that position because their job is to facilitate a resolution. Definitely don't want to come into a mediation fixed and stubborn and refusing to compromise. It's not going to be productive. Have to keep an open mind to understand that, generally speaking, there in any case, although there are exceptions, most of the time, in my personal opinion, every case is kind of a mucky gray, meaning it's very rare where you have a really clean person and a really bad actor. Usually both sides, kind of like a divorce in a family situation, both sides generally have some level of culpability. You have to have internal acknowledgement that, look, maybe there's a way to compromise and move on. Maybe I wasn't the best employee possible. Maybe I rubbed people the wrong way. Maybe you didn't. Maybe they're just, really bad actors. That certainly happens, and it happens all the time. That being said, even if they're the worst possible actor, the law limits damages significantly, meaning even if you prove every element of your case, and even if you prove maximum damages, there's statutory caps on damages, so you can only get a certain amount of money, which I think is personally unfair. I think it's a violation of the Seventh Amendment. I'm a big believer in the Seventh Amendment. I'm a very strong advocate of fully supporting the Constitution as written and not having arbitrary statutory limitations on damages. I think that's a violation of the right to a resolution of your dispute by a jury. However, my personal belief and the actual law are divergent usually, and we have to live with the reality of the fact that damages many times are capped by statute. So even if you prove everything you're saying, you're still limited with the universe of what you can get in response. And you have to learn that mediation is going to be a settlement valuation, a fraction of your ultimate potential maximum recovery. What that means in English is if the law says you can only get 500,000, you demand 500,000, but they're not going to just write a check for that. They're going to give you a percentage of that in a mediation. So if you wish to resolve your case with guaranteed funds, you're taking a percentage of what's generally available if you roll the dice through litigation. Think of litigation as like roulette. Is it possible to go into a casino and put $100 on two black and win $3,400? Absolutely, it's possible. But you also know there's 36 other numbers on the roulette wheel, or however many numbers there are. I don't play roulette too often, but the example is, yes, you could hit two black, and those two black hits make the paper. They make the front page. Mr. Smith wins $10 million against Exxon. But there's a reason why Mr. Smith winning $10 million against Exxon makes the front page, and the other 9,000 cases being litigated that week don't. It's because it's rare and it's uncommon. So keep that in mind. One of the biggest frustrations I have as an attorney, 15, 16 years now, is people see stuff in the news or in the paper and they think, oh, well, Mr. Smith got $16 million, so my case is worth at least double that because his facts were pretty weak. Well, you don't know the facts. You know what the press says. And the information in the press is a blurb, not an accurate description of what really occurred. And beyond that, the reason why it's newsworthy is it's an exception to the ordinary course of business. There are unusual circumstances. I've had 7-figure settlements. Do I have 7-figure settlements every day? No, those are exceedingly rare. But in the course of my career, I've had a handful of cases that have hit that valuation, and so has Mike. But generally speaking, cases don't usually hit that valuation. Believe me, if I was settling billion-dollar cases every day, I wouldn't be doing this anymore. So they're just not common. So keep that in mind when you're litigating your case and you're trying to resolve it in mediation, is that there are legal limitations on maximum recoveries. There are exceptions, there are rare exceptions, and your case very well may be that rare exception, but statistically speaking, it's unlikely. So how do you engage in the mediation in federal court? We'll go on to that next. So let's move on to the next slide, to slide 11, please. What is mandatory mediation? Mandatory mediation basically means, generally, the way I see it come up is the judge for the court where the lawsuit's been filed has a pretrial written order that disputes of this nature will go to binding ADR, meaning they're going to facilitate mediation. They're going to mandate it. You go to it, and they're going to want you to participate before they get into the weeds of your resolving your disputes over whether you produced every document you should, whether all the emails should be turned over, whether phone records should be subpoenaed, whether witnesses should be compelled to provide testimony, whether you get access to experts, all kinds of information that can be avoided litigation if you just go to mediation and resolve it early in the process. And it saves everybody time, expense, and effort if you file a lawsuit and go to mediation versus getting stuck in the weeds of discovery. Sometimes mediation is mandated by an employment agreement, employment handbook. Arbitration could be a precursor to binding mediation through litigation, meaning you might be required to arbitrate before you can litigate. Arbitration is usually a third-party type judge, the American Arbitration Association, or similar ancillary process. And if that process resolves the claim, your case ends. If arbitration doesn't resolve all the claims, or the claim is something not subject to arbitration, then your case may survive and go into federal court or state court, and then may ultimately go to mediation. For disputes where mediation is mandatory, the judges will require both parties to participate in good faith. So the judge will want you to be involved in your mediation with an open mind and negotiate towards a resolution candidly, disclosing pertinent facts. The good thing about mediation is you can disavow settlement valuations. So if you think your case is worth $2 million, and in mediation you tell the other side, I'll settle for $200,000, you're not bound to that $200,000 all of a sudden. You can disavow that and go on with litigation and continue to seek your full maximum recovery. That's why I like mediation, to flush out what is the defendant really willing to pay to get rid of the case. What does their internal evaluation say the case is worth? Sometimes they think the case is worth a nuisance value, meaning a very small amount of money. Other times they understand a significant risk and they're willing to pay lots of money. In fact, Mike and myself have had mediations where our own valuation assessment was on the lower end and defendants offering more money, and we realized later they were doing so because they didn't want to proceed, because they didn't want to uncover even bigger issues that they were trying to prevent disclosure of. So it can go either way. You want to participate in good faith. You want to make sure you are candid, give all the facts. Never hide facts from your lawyer. I know that sounds like common sense, but your lawyer needs to know all the information, good, bad, ugly, and your lawyer is not going to, or should not, judge you for mistakes you've made in your life that may give you embarrassing bad facts. If you have bad facts, you need to tell your lawyer immediately, so your lawyer can do the lawyer thing of spinning those bad facts into either obscuring that from reality of disclosure or massaging that into something useful to assist you in resolving your claim. But you got to give the lawyer all the information. What I don't like is when my clients actively conceal information from me, their advocate. I can't help you if I find out later through document production or through other sources, the information you're telling me is not accurate. As an attorney, we have a Rule 11 duty, candor to the court, present information honestly and openly, and not deceive opposing party or deceive the judge on information. So if you tell us stuff that turns out to be incorrect or knowingly false, it may necessitate withdrawing from representation or corrective action, and it puts you in a very bad position. So tell your lawyer all the bad stuff first, and then the good stuff, so you can work the information in to just resolve your case. If you relate to work,
You don't need to tell your lawyer you were always on time. Just admit to your attorney, look, I was late several times. Maybe they can blemish my record up a little bit on the fact that I wasn't doing everything I was supposed to do. It doesn't excuse the fact that when I got pregnant, they fired me immediately and didn't fire anybody else who had similar blemishes. It just means we know the details and we can anticipate what they're going to say in response. Generally, what employers do when they wrongfully terminate somebody is they try to paper over the fact that they engaged in discriminatory conduct. So if they fired you for being pregnant, it's very rare they're going to come out and say, yeah, we admit we don't like people who are pregnant. That's not what they're going to say. They're going to say, well, we fired you because you were deficient at your job, and we noticed your deficiencies because A, B, and C. You can help us determine if A, B, and C are baloney or if they're legitimate. And if they are legitimate, maybe they're de minimis. Maybe it's not enforced against anybody else and only against the individual with the protected classification. That is what's called subterfuge, and that would still be evidence of illegality. So it's not necessarily terrible to have some bad facts. You have to just manage those facts in a way that's presented in the best light possible. And yes, the opposing side will actively interpret events and information in a manner far different than your recollection of events. That's to be expected, though. So don't lose sleep over the fact that they're going to say, yeah, you were terrible and you didn't know what you were doing, and absolutely we had to get rid of you. That they say that every case. The other thing they say every case, almost universally, is when we send a demand, they usually almost always write back, oh, we looked into your claim and it has no merit. That they say every claim, almost every time. In fact, I'm surprised when they say, oh, we messed up, we're so sorry. That happens about 10% of the time. 90% of the time, they write back saying, two middle fingers in the air, your claim has no merit, it should go away. However, we try to facilitate a negotiated resolution because they understand that's not likely accurate and that's posturing, and we're going to demonstrate why they're exposed. So we can move on past slide 11 now to slide 12. Steps to engage in federal court mediation. So, sometimes you can file a motion to compel mediation. You can file a motion to participate in ADR, notify the parties, select a mediator. You always want to do an assessment on the mediator. There are certain mediators that are plaintiff friendly, some are defense friendly, some are neutral, some are great, some are flatly, frankly, incompetent. It's a mixture, just like any ordinary Starbucks employee. Some are great, some are awful. Same with attorneys. Some are awesome, some are deficient. Mediators, no different than that. So you want to look at the reputation of the mediator. You want to do a background assessment. You want to ask other attorneys who've been involved with that mediator what their opinion of those mediators are. Because a lot of attorneys, a lot of former judges, they, especially in Texas, they're voted by election. So if they lose because they're in a county that swings, meaning that they voted in and they voted out and back and forth, in between being elected, they may go do a mediation. They may not be the best mediator because they're just kind of holding off till they get their next elected position. Others are mediations for decades exclusively, and they're really great at what they do. So I'm always skeptical of a former judge setting up a mediation shop immediately after losing an election, because their heart's not in it, and they may or may not be competent in the area being mediated. They may not have had any cases before them that actually were specific to your particular issue. You want to have a mediator with knowledge of the law you're pursuing. So if you have a mediator that only does car wreck cases, you probably don't want that mediator to do an employment dispute. And if you're doing an employment dispute specialized like USERRA, which is the Uniform Services Employment Re-Employment Rights Act, you want a mediator who understands issues associated with veterans and associated with military service, not a mediator who has no knowledge of the military and no knowledge of, that whole process. And unfortunately, in my experience, a large number of mediators wouldn't even be able to tell you what USERRA is, let alone the fact that it's an enforceable law that's very paternalistic and very helpful and very pro-plaintiff. So you want to make sure your attorney does a background check on the mediator, flushes them out, makes a suitability assessment and a determination that the mediator you're selecting is sufficient and qualified and capable to give you the best representation possible in the role of being a mediator. You don't want a one-sided hack that's basically in the hands of the corporation, and the corporation doesn't want a mediator who's excessively pro-plaintiff, because they're not going to take it seriously and they're not going to resolve the claim. So it'd be a waste of everybody's time. So you want a mediator who truly is neutral, detached, and fair. You want an umpire or a referee that calls the game fairly. You know, you need an umpire with a strike zone that matches what the rules require. You don't want one that's got their hand on the scale in either direction, because it's not good for either party to get a resolution. It may be beneficial to one part or the other temporarily, but in the long run, it's detrimental to the fair resolution of claims and the mediator's reputation. Ultimately, they won't be mediating cases too long if they're not good at what they do. So you want someone who's been doing it for a while, ideally, if you can find someone. If costs are an issue, oftentimes magistrate judges who are federal judges hired to assist the appointed judge, it's Senate confirmed, they will offer mediation at no cost. Some of those magistrate judges are really good, and some literally just took the bench last week and have no idea what they're doing. So you really need to do an assessment from attorneys that have practiced before those magistrate judges to make it a determination on whether that magistrate judge is good or not. Some magistrate judges are great. Others, I don't want to insult anybody, but some are not desirable. So that being said, the only way you'll know that is by talking to individuals who've been before them. And if that magistrate judge happens to be deficient for a certain reason, you may not want to mediate with that individual. And another one has a great reputation for getting claims resolved that are contentious and scorched earth fights, then you may want to participate in mediation with a magistrate judge. Saves costs. Otherwise, paying out of pocket for a mediator is usually worth the financial investment. Mediation fees can run anywhere from $500 on up, $2,000, somewhere in that goal range is generally around the cost. That's a wide goalpost, but again, depends if it's a half day mediation, a full day mediation, if the mediator is charging a flat fee or an hourly fee, and that fee goes to the mediator directly, not to the attorneys participating in the mediation. So everybody's got their hand in the cookie jar there, but the mediator, has expenses too, and has staff, and has to earn a living, so they charge for their services unless they're being paid by the government and they're a federal magistrate judge. Then they offer mediation generally at no cost because they're already getting a salary from their federal job. So let's move on to the next slide. All right. Steps to engage in mediation continued. Basically, you go through mediation. The mediator will then, after conclusion of the proceedings, file a report whether the case was settled or not. If the case was settled, parties will usually agree to file what's called a stipulation of dismissal or a joint motion to dismiss, meaning the case will be removed from the docket. And as long as the terms of the mediation are complied with and a settlement agreement is finished, generally the case is over. It's possible you may have a breach of contract claim if, say, XYZ defendant agrees to pay you $1 million, and then they say, you know what, we're not paying anything anymore. Then you could certainly file a motion with the court to enforce the terms of the agreement. Same thing on the plaintiff's side. If the mediation says non-disparagement, meaning you both agree not to slander each other or say bad things about each other, and then you go on the internet and say, I work for Pepsi and they're terrible, they're a bunch of, jerks and sexist bigots. It may well be true, but if you signed a confidentiality agreement, non-disparagement clause in exchange for compensation for your settlement, saying those things would be a breach of your agreement and you'd be subject to being hit with damages. Meaning, even if you can say those true things, absent the fact that you contractually agree to be paid not to say those things. So be careful if you do settle your case through mediation and a signed binding agreement, and it says non-disparagement, you want that non-disparagement so your former employer can no longer tell potential future employers, hey, this person was terrible at their job. That's what they probably were doing until you filed lawsuit and got your claim resolved. Now they're just going to give a neutral reference, say, yeah, they work from this date, and that's it. That's what everybody wants. In exchange, you have to do the same thing. You can't say to other people like on Glassdoor or online reviews, Yelp or Google or whatever, oh, my former employer was awful. You just can't say anything because you've been paid to be quiet. That's part of the compensation valuation assessment on whether, if you want to settle, is it worth giving up your First Amendment right to warn others about how terrible your former employer was. If you want to warn others about how terrible your former employer was, you certainly can do so, but you're not going to get a settlement through at least early in the litigation. But both parties are going to desire a non-disparagement clause to prevent leaking information that neither side wants published publicly. We can go on to the next slide. So How do you prepare for your mediation in Texas? Well, you want to know your case to the best extent possible. You want to make sure your attorney has all the information necessary. And your attorney should provide the mediator with an opening statement and documentation supporting the contentions contained in your position. So if you're a plaintiff pursuing a wrongful termination, you want the mediator to understand your version of events. The other side will tell their version of events. The mediator will be able to understand there's obviously facts in dispute and try to resolve this and get you to the negotiation stage to get your claim, resolved. We can move on to the next slide. Stage of mediation. That is, this is the part I do want to share a couple of war stories with. We'll open up our demands really high, and sometimes my clients get all big-eyed. Oh, we're asking for $1 million. Great, I can't wait to spend it. That's not how it works. We start with a very high demand, knowing they're going to come back with a very low offer. And the idea is to work the numbers until they get to some kind of resolution, ideally somewhere in the middle. So you're starting off with a $100,000 demand. The other side is not going to just come back and say, oh, 100,000, that's it. Okay, here you go. Okay, that mediation is not going to end that quickly. They're usually going to start with a lowball offer of $1,000, $2,000, maybe $5,000 or $10,000, but they're never going to come anywhere close to your initial opening demand. You want your opening demand to be a multiplier of what your final settlement value is, meaning many times what you'll actually take to settle your case, what your opening demand should be. And then you settle the case for evaluation between those numbers. That process can take a long period of time to explain to both parties risk associated with going forward and why valuation needs to be met somewhere between the two numbers of the extremes. Nobody's going to just take a couple $1,000 to go away from mediation. There's no point participating. At the same time, you're not going to get 7-figure resolution in mediation, generally speaking, unless your claim has unique facts. So you have to keep those two things in mind as you go through the stages of the mediation to facilitate a resolution. Let's go on to the final slide here. Stages continued, slide 16. So the structure of the mediation may involve a lot of different elements. You may have a introduction session. I always like to have those. I like to go meet the opposing counsel. I like to show them, we're professionals and we're here to mediate in good faith, and we're serious too. You want to have a poker face on mediation. You want to demonstrate, this is your opportunity to pound your chest. None of this is producible or admissible, or you don't have any rules that require authentication of evidence or admissibility concerns. So you can bring everything to mediation and really try to bluff out the other side. And the idea is to hope that they understand the risk. And if you did get all that evidence into trial, how messed up the case would be and how exposed they would be to a jury and how much money they may have to pay if a jury was adverse to them. So mediation is your opportunity to really use some extreme aggressive tactics to really pound your chest about how strong your case is. Whether it's truly that strong, the evidence the judge will make that determination about the duration of the trial. But mediation is your opportunity to really aggressively tell your side of the story. Now, the other side is going to do the same thing. They're going to say, your case has no merit. We're going to get dismissed. There's no chance of surviving an early dismissal. We're going to get it killed on a procedural technicality. Don't lose sleep over any of those claims. They say that in every single case. The defense playbook, having defended insurance companies previously, I can tell you in every claim, insurance companies across the board generally underpay everybody across the board. That's their business model. They wouldn't be in business if they were paying claims correctly because they wouldn't have any money left over. So they lowball everybody, knowing only a small percentage actually care enough to go after what they're fully owed. So they make money off of those who don't fight back. And it's really an ongoing, in my opinion, a scam. It's really unfortunate because a lot of good people get victimized by unscrupulous insurance carriers and unscrupulous insurance companies. And I also say this too, because insurance companies are terrible clients. They pay their attorneys, say they pay their clients. They're claimants, meaning not good, not well at all. So I try to stay away from, in the future, representing insurance carriers because they're just not, in my opinion, the best individuals to interact with. They generally don't pay their attorneys, they don't pay their customers, and they keep as much money for themselves as possible. And they're the worst possible bad actors out there. And it's just a business model. And it's been very profitable for 100 years plus. So it's going to stay that way indefinitely unless the law were to change. So until the law changes, that'll continue indefinitely. Employers, I will say this, when it comes to mediations, private employers are generally more open to settlement and mediation resolution. And I think the reason behind this, and Mike may have different opinion on this or may have elaborate to, I may not be giving all the information on this, but I believe private employers are more likely to entertain settlement and settlement early versus government employers, because private employers are worried about their public reputation, their stock price, compliance with the SEC, shareholder lawsuits, and issues that a government actor is not worried about. And the government actor, when they violate the law, the taxpayers are on the hook. So the people who are actually violating the law are generally immunized by government immunity. So generally, I hate to be crass, but often they don't care. So when you sue the city of Houston or the city of Dallas and are egregiously violating the law, they often hide behind government immunity. Well, IBM, Dell, Samsung, you name it, they don't have government immunity. They have shareholders. They have a public reputation to defend. They have to also recruit employees to work for them. So they have to care about factors that a local government simply doesn't. And local governments often just hire an outside firm that's given the people hiring them kickbacks. So that outside firm has every incentive to bury you alive in paper to make you go away, hoping you won't pursue your claim. So I find quite a few law firms out there love to milk municipalities of resources and basically bleed taxpayers dry because they help protect jurisdictions who engage in bad conduct, and they hide behind government immunity, whereas private employers don't have that. So if you are a victim of discrimination or unlawful treatment by a private employer, be optimistic. The law is on your side, and the company, if they get exposed, is more likely to try to clean it up quickly to avoid the humiliation of the exposure and liability. Government employers, it's much harder road. In fact, the biggest violator of USERRA, ironically, is the Department of Defense, and it's designed to protect veterans. So what does it tell you? It tells you a lot of people who are bad actors work for the government and hide behind government immunity and engage in misconduct and then try to get away with it by misusing their government position. It's very unfortunate. We litigate through it and we get resolutions for individuals, but it's a much more difficult struggle, generally speaking. And again, this is all very generic. It's not universal by any means, but it is my experience having done this now for 8.5 years in private practice with this firm. So with that said, I think that covers our overall scope of mediation, and I've probably given out more information than necessary. So please ask questions, because I may have generated some questions from the fire hose information we've shoveled out here.
And there's a question we just received that is, if you representing yourself pro se for your entire case now at the mediation, can a lawyer be hired for the mediation? Yes, you can hire a lawyer for your mediation. You could contact a lawyer to represent you during the mediation. And I guess the second part, and it does not disqualify or remove all the laws that are available to whom represented themselves. Not exactly clear there. All I'll say is, you hiring a lawyer to represent you should not harm you. I mean, that you hire a lawyer to help you. And the point is, if you need a lawyer to assist you in your mediation, that does not take away any rights you have.
Another question we got is, Texas courts favor employers? Yes, absolutely. I'll comment on that. Is Texas's population has skyrocketed largely because so many employers have relocated their operations to Texas to encourage people to relocate here. Other people have moved here because of weather and other related issues, but a large number of employers have moved operations here specifically because the law is more favorable to them, and they can make more profits here in Texas than they would in other states where they're having to pay for liability for engaging in misconduct. So there's a two-edged sword to that. It helps the economy to have more jobs, but it also hurts the people who are victimized by unlawful treatment. So I wish there was a better balance between those. Unfortunately, I believe, having lived in both states, Texas and New York are kind of extremes of each other. My personal opinion, Texas is kind of like the Wild West, and New York is kind of like, let's suffocate you in paper and choke everybody to death with regulation. Both are extremes of ideological spectrums that I believe there needs to be a balance between those two. You should be protected and given protections. Texas does not offer as many as they should, And in New York and other jurisdictions, they do make it very difficult to run a business. Often people are burdened by bureaucratic entanglements that make profitability difficult, which encourages them to go to places like Texas, which literally is like the Wild West in many ways. That being said, even though Texas is the Wild West, the federal rules still apply. And the federal rules, Title VII, anti-discrimination provisions are applicable even if Texas has no additional protections. You can always ask for a maximum valuation of your, there's a question on damages, $300,000 cap. You can ask for legal fees. They may be awarded occasionally. You can ask for lost wages. You can ask for emotional damages. All that stuff you can ask for. Again, at a mediation, you're probably going to get a percentage of that offered as a settlement. You're not going to get the full amount you'd get awarded from a jury. A jury can offer you, say, I'm just making this up, $800,000 if it includes lost wages, attorney fees, emotional damages. But a settlement through a mediation is going to offer you a fraction of that as a percentage because it's guaranteed funds up front versus having to go to a jury and litigate it over the course of several years. From the time you file your lawsuit to the time you get a jury verdict, often takes 1 to 2 years. And then beyond that, if the verdict's adverse, the employer can go to the Fifth Circuit and tie the case up for years, meaning it may take 2 or 3 years till money's ever exchanged. So having guaranteed funds to mediation up front is in your best interest in the long term, and if the value of it's high enough to be worth not waiting for. Does a company's yearly financial statement help mediation? It could. If a company is very profitable, they may be more inclined to offer a higher settlement valuation, especially if they want to avoid the negative publicity and have their stock price collapse because of bad social media press or something along those lines. I mean, Boeing's been killed in social media because of all the whistleblowers that have been harmed, and their stock has gone down significantly because of the bad news cycle they've been in for all the issues associated with whistleblowing. This is one example of the fact that, yes, companies' financial position will indicate their settlement valuation to some extent. But again, it's case-by-case determination on that. Yeah, everything is really case specific. If you have a very specific question about your particular facts, we offer consultations here at our firm. Anybody's welcome to call our intake at 832-241-5888. Myself and Mike handle consultations on a day-to-day basis. We talk to employees, we talk to employers, we talk to anybody who needs a consultation, who sets an appointment up with us. There has to be a conflicts check because if we represented somebody who's got involvement already, be conflicted out through ethics rules or prevent representation. That's why we ask you call our screening process first so they can do a conflicts assessment to make sure we can talk to you. That's really critical. So a lot of people just cold call me throughout the day wanting to talk to me immediately. I can't ethically do that because I have to make sure there's no conflict of interest, and that has to be screened through our database initially. That's why an appointment is required. Mike, do you want to add anything to that before we close up?
No, I think, the case specific questions are difficult to answer. Like I said at the beginning, this is meant for a guidance on the federal court mediation process. But as put up on the screen, you have our contact information, as also Sean just provided. So if you do have more specific questions over your case specifically, please contact us and we're happy to do a consultation.